Thank you. Mr. Radford, you have Jacobian Dorsey.
Yes, ma'am.
Dorsey.
Set the case for trial.
Did you do a rejection?
I think it's already been done, but you know.
Let me, I'll check real quick and see. Was there anything, hold on, you might not have to do one. Is there anything that's,
But he's already, I think I caught lawyers.
we're not gonna call them that.
Okay, I'm sorry.
Mr. Coleman's notes look like he hasn't changed the offer or anything, Your Honor.
Looks like, the offer was 20
Yes, stacked.
to stack on top of a sentence he's doing correct now, correct?
Yes, ma'am.
All right, sir, you're Jacobian Dorsey.
Yes, ma'am.
And Mr. Dorsey, in cause number 25, DCCR 1896, you are charged with manslaughter. And we've gone over this before. Let me pull it up. Is there the indictment alleges second-degree felony offensive manslaughter, but looks like the state's filed a notice of intent to use prior conviction to enhance your punishment, which means we've gone over before. And when you sign that plea bargain rejection with Mr. Parker, that the state, you would be looking at a first-degree felony if you're found guilty for punishment purposes, which means the minimum punishment would be 5 years up to 99 years or life in prison. You understand that? Yeah. And the same offer is on the table now, which is a 20-year term in prison that would be stacked on top of a sentence that you're currently serving. Is that your understanding of what they've offered you? Mm-hmm. And you want to reject that and move forward with trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Radford will begin preparation for trial.
Excuse me, that that I'm actually doing time for right now already, that's on appeal.
Okay.
But that's not a full conviction.
All right. Well, if it'll all depend on when we get to the trial. I'll set it on the trial docket. If something gets affirmed by then the conviction would count. If not, then there's some legal issues that we'll take up at that time, which means it would be potentially just the 2 to 20, but we'll take that up at pre-trial.
Judge, it looks like a case has been brought over this week from something that happened in the jail. It may be a new harassment or assault on an officer. I think that's going before the grand jury tomorrow, if not tomorrow, next week. And I just asked that we put this on the trial docket. I don't think it's going to change.
No, yeah, we're going to go to put this one on the trial docket and then we'll deal with that one when it comes.
Thank you.
Thank you, Mr. Nichols. You can go back with the bailiff.
May I be excused?
Yes, sir.
Thank you. Yeah, I'll put that.
Good job.
What do you learn? You gotta go into the following.
And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Park?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, 3rd or more. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will also, as part of that plea agreement, sign the dismissal in cause number 25 DCCR 1211. I'm handing you the trial court certification, shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff. Ronald Barrett.
Can you do?
Ronald Barrett.
Okay. Go with that. It's what Tom's case. That's
Looks like Mr. Nichols is on that one.
We've got it covered.
Yeah, I've got it.
I'm just letting you know, I mean, y'all wasn't saying today.
Actually, it's my case.
Oh,
They've been, most of it has been.
It said Tommy.
No, it's no longer says.
Oh, on my reset, sorry.
You've been around this.
Right.
Sorry, case.
Good morning, sir. Are you Ronald Barrett Jr.?
Yes, no.
And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Barrett, in cause number 26 DCCR 0890, you're charged with the state jail felony offense of unauthorized use of a vehicle,
Yes, ma'am.
and that's from January 28th of 2026.
Yes, ma'am.
The indictment alleges that you were previously convicted of unauthorized use of a motor vehicle August 3rd of 2009.
Yes, ma'am.
And after that was final, you were convicted of possession of a controlled substance March 22nd of 2011.
Yes, ma'am.
And then after that, convicted of unauthorized use of a vehicle April 14th of 2011.
Yes, ma'am.
And then again, unauthorized use of a motor vehicle June 26th of 2017. And then burglary of a building August 24th of 2022. And how do you plead to that charge?
Yes.
And are all those prior convictions true?
Yes, ma'am.
I don't understand this agreement at all.
Judge, the vehicle in question is a scooter taken from a known address. The complainant that's well known.
And
Of me in the court.
I will also tell that there's been some cooperation with.
Okay.
Law.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And obviously you can tell that I don't like this agreement, but I understand there's some circumstances that Mr. Nichols and Mr. Parker have negotiated for that.
Yes, ma'am.
I want you to understand if you come back in here on another offense where you're stealing a car or getting into a building or stealing, I don't care if it's a scooter, I don't care if it's a Snicker bar.
Yes, ma'am.
You will not get an agreement like this again, regardless of what you've done. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Barrett's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Also that you entered those pleas of true freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find this prior offense is true. Sentence you in accordance with your agreement to a term of 2 years in the state jail, in the Texas Department of Criminal Justice.
Yes, ma'am.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you.
Yes, ma'am.
If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, ma'am.
Good luck to you, sir. You can go back with the
Thank
paper.
you.
All right, thank you. Sean Johnson,
It's rejection. He may be, he may be. This.
snowboarder. Isn't that his name?
Huh?
Yeah, the snowboarder.
Oh. I was thinking of the gymnast.
Oh, yeah. Perfect. Okay,
That's what I thought.
no, getting confused.
I'm gonna Sean White.
Yeah.
Right. Sean Johnson is the gymnast. Probably not the same, definitely.
That's fine.
Good Good morning, sir. Are you Sean Joe Johnson?
Yes, ma'am.
And Mr. Johnson, in cause number 26 DCCR 0924, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from March 6th of 2026. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, July 8th of 2016. And then after that was final, you were again convicted of burglary of a habitation, a second-degree felony, February 15th of 2017. And what that means, sir, is that if you go to trial and you're found guilty, you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker, and I'm guessing you guys, it says months are checked off.
I'm sorry. Yeah.
So it shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 12-year term in prison. You have every right to reject that offer and have your case set for trial. Just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty. Do you understand all that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Mr. Parker has been appointed to represent you. He's one of the cases. He's one of the lawyers who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who could begin preparation for trial a little quicker. Is that okay with you?
I'm gonna do a turn.
So I'm going to release Mr. Parker. We will appoint someone today, Mr. Johnson. They should begin preparation for trial very soon. Mr. Smith, is there any reason to believe or anything that you're waiting on that offer would be reduced with a different attorney? So I do want to make sure you understand that a different attorney is not going to necessarily get you a different deal. And that typically after today, I don't take those deals that you've already turned down. If something comes up that's different that your attorney doesn't know or the DA, then I'll consider it. But whoever that is will be out to see you very soon and begin preparation for trial.
Yeah.
All right, you can go back with the bailiff.
Yeah.
See, Miss Holmes, you got Stormy Folwell.
Ron, forward. Go through the motion, we can do an updated PSA.
I think that you need to know exactly what you're gonna do on this one, though.
Yeah.
Oh, I do. Y'all do?
Mhm.
Well, how would you prejudge? Is it that clear?
She's very clear.
Oh.
This is it's one of those special drug things that the minimum is 10. Where she pled.
Garrett, how's it going? I'm getting to get over.
She's with the child.
She's been to St. Pete twice.
Good morning. Are you Stormy Folwell? And will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Folwell, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Ms. Folwell, in cause number 21-38655, I have a motion to revoke your community supervision. Shows that you were placed on probation January 26th of 2022 for possession with intent to deliver a controlled substance, a first-degree felony. And that was a 10-year term in prison that was probated for 10 years. Is that correct? The motion alleges that you violated your probation. It alleges in count 1 that you provided a urine sample January 26th of 2026 that tested positive for methamphetamine. Is that true or not true?
January 22nd.
January 22nd of 2026, excuse me. Is that true or not true?
Yes, sir.
True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
True.
Count 3 alleges that you failed to successfully complete the SafeP program and that you were unsuccessfully discharged from the supportive outpatient treatment on January 22nd of 2026 because you tested positive there for methamphetamine, amphetamine, and ecstasy. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening January 21st and February 2nd of 2026. Is that true or not true? But that is not true. Count 5 alleges that you're behind in your court assessed fees as of February 6th of 2026 in the amount of $4,205. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm going to reset your case for sentencing and ask the probation department to do an updated report that'll give me more information about what's been going on. Also, if there's anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Thank you for being here, ma'am.
Stop.
Jasmine Hancock.
Yes, sir. Those are the objections.
Okay.
Office.
Yeah.
Good morning, sir. Are you Jasmine Tyrone Hancock?
Yes, Mom.
And Mr. Hancock, in cause number 25 DCCR 0737, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from April 22nd of 2025. The indictment alleges that you were previously convicted of evading arrest or detention August 9th of 2013. Some of these are with vehicles, which would make them different. Looks like we've got an evading with a vehicle, April 23rd of 2008, another evading with a vehicle, December 1st of 2008, and evading with previous convictions, June 12th of 2017, and evading also with previous convictions, June 12th of 2017, and evading with a motor vehicle, 2 cases on June 12th of 2017. Then the indictment further alleges that you were convicted of unlawful possession of a firearm by a felon, February 9th of 2009. Also possession of a controlled substance on that same day. And then after those were final, you were convicted of burglary of a habitation, June 12th of 2017. Well, what that means is that if you go to trial and you're found guilty and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, Mom.
So in clause number 25, DCCR 0738, you are charged with the third-degree felony offense of continuous violence against the family, and that's from April 26th of 2025. And it alleges those same prior felony convictions, which in this case means that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison up to 99 years or life. Do you understand that as well? And then we've got cause numbers 25 DCCR 1233, which is another evading arrest or detention with previous convictions. And that's from August 5th of 2025. And then we've got 26 DCCR 1018, which is also an evading arrest or detention with previous convictions from March 18th of 2026. Those are both the same as that first one with those prior offense convictions that would make these second-degree felony offenses for punishment. You understand that? In all 4 of these cases, I have here on the tablet some plea bargain rejections that you've signed with Ms. Holmes, and it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. For the evading arrest or detention cases, it looks like it would be cause number 250737 and
I think I did.
1018. There would be 12-year terms in prison with dismissals in the other evading and that continuous family assault case. You have every right to reject those offers and have all of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you want to plead guilty.
Yes.
You understand all of that?
Yes.
I also want to make sure you understand that if you are found guilty on more than one of these, because they're different offense dates, there is the possibility that any sentence you receive on more than one could be stacked on top of each other. Do you understand that?
Yes.
And do you want to reject all of these, the offers on all of these cases and have them all set for trial?
Yes.
Mr. Nichols, is there any reason to believe that these offers would change or?
No, Your Honor.
So I do want to make sure you understand also, Mr. Hancock, that after today, I will not accept these plea agreements.
Yes.
Once your case goes on the trial docket, it goes to trial, or you can enter a plea either open to the court or to some different.
Yes, ma'am.
You understand all that?
Yes, ma'am.
All right, then we'll get it set on the trial docket. Mr. Hancock, Ms. Holmes has been appointed to represent you at this point. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
Yes.
With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Ms. Holmes, I'll release you. We will appoint someone today. They should be out to see you at the jail very soon to begin preparation for trial.
Yes, ma'am.
All right, you can go back with the bailiff. All right, on Jonah Johnson. Good morning, sir. Are you Jonah Johnson?
Yes.
And Mr. Johnson, in cause number 25, DCCR 1775, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. And it looks like, has there been I guess I'm confused because the offers,
25 should be 20. It's 2 to 20.
it's a 2 to 20, and I don't see, is there going to be, or has there been, I don't see a notice of extraneous other convictions.
There is no, that's right, Judge. The max is 20, Judge.
So really, there's no offer. It's just to plead open or plead guilty to the max. Is that?
Judge, I was a prisoner's first degree. Let me
Punch up.
draw that offer.
Yeah.
The state's offer now is 15, Judge.
Okay, I'll hold it for a minute if y'all want to visit about that, or I can.
We've already talked about that.
Okay, so it doesn't matter if
It
it's,
doesn't matter.
okay, so with everybody's permission, I'll make that change here on this document.
Please, Judge. Thank you.
All right, so Mr. Johnson, what that means in your case is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes,
And I have the plea bargain rejection that you've signed with your attorneys that shows that the district attorney's office has made an offer of 15 years in the institutional division. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty.
yes,
You understand all of that?
yes.
And you want to reject that offer and have your case set for trial.
Yes.
All right, we'll get that done. Also, is there any reason to believe any evidence that you haven't either received or waiting on, or that would change this offer?
No, Judge.
And as far as you guys know, y'all have asked for, everything's been received through the portal. Any media? Is there anything else that's outstanding that you know of,
Oh,
media wise?
No, Judge.
Okay. So y'all have requested and received the media if there is any? Perfect. Okay, so I just want to make sure you understand that after today, unless there's some new evidence that comes up that your attorneys or the district attorney does not know about, I will not accept this plea agreement. So after today, it goes on the trial docket, it'll go to trial, or there'll be a plea to something else, or if it's going to be this or lower, it would be because there's some new evidence. Does that make sense?
Yes.
All right, we'll get it set on the trial docket, and we'll let you guys will get a notice by email.
Judge, may I ask this court's permission? It's my first time trying
Sure.
to case for you.
Yes, sir.
By the end of this hearing, one message stands above everything else. Every decision in court carries real consequences. Whether accepting a plea deal or choosing to fight the charges at trial, the judge ensures that every defendant fully understands what's at stake before making that choice. What would you have done in their position? Accepted the deal or taken your chances at trial? Let us know in the comments. And if you enjoy real courtroom breakdowns and legal analysis, don't forget to like, subscribe, and turn on notifications for more court highlights.
Yes, sir.
Does this court set kind of like a docket control order where there might be a motion setting or anything?
So what I do is I'll set a pretrial
Okay.
the week before the trial date.
Okay,
And typically our trial dockets are about 8-ish cases or so. And so on the pretrial, I will go through and see who's ready, who's not ready, whatever the case is. And then I'll order those for the next week. So you would know on the Tuesday prior what number you are. If you're at the top or close to it and there's some pretrial issues that we need to deal with, we could do it on that day. Or if it's the number one case, we can do it on that Monday before jury selection, depending on what those pretrial motions are.
Okay.
If there's something that is going to require more time, some type of suppression or some hearing that will take witnesses and more time, please get that filed quickly and I'll get it set well before that so that we can have that taken care of.
Yes, ma'am.
Okay.
All right. Thank you, Judge.
All right. Thank y'all.
May be
Thank you.
excused.
Yes, sir. You go back with the bailiff.
All right, we'll see.